Hello world, my name is Jaime Pop. I'm the owner of JVP Law. I was born to be an attorney and I absolutely love this stuff. So today I want to talk to you about estate planning. Brought a document here just so I don't go on some tangent and talk to you forever. Just keep on point, right? So estate planning. I want to talk to you today first about structuring a comprehensive estate plan for you and your family. So this is going to be the first video of a series I'll be publishing to the community just to help you all understand estate planning, eventually commercial litigation and business law. But today we're going to be talking about estate planning. So generally when I work on estate plans for individuals and families, it's a 41-step process, structuring and executing a strong estate plan. One of those steps is to determine if your plan will be better suited with a trust or a will. So of those 41 steps, one of those steps, and it's really more than 41 steps, one of those steps is to determine whether you want to have a trust or a will. And to understand that, we need to talk about the difference between those two. So let's begin. And first I want to talk to you about what a trust is. And next we'll talk about what a will is. Okay. All right. So that said, so a trust comes from the property code. A will is kind of born or comes from the probate and estate code, right? So right off the bat, the difference between a trust and a will is there's two different bodies of law governing them, right? So because a trust is not in the probate and estate code, it does not go through the probate and estate process, right? It doesn't go through the probate process, right? The probate court. Because on the will, on the other hand, does come from the probate and estate code. Therefore, it does go through the probate process. So one big reason individuals love to have trust, right, is because trusts avoid probate, right? Why do people want to avoid probate? Because probate is generally can be very expensive, right? And so that's just one reason, right? It's one reason individuals choose trusts. But as you may see after I finish this discussion, there are a medley of other reasons why individuals choose trusts over wills. Now they both work, they both do work, and they do what they're supposed to do. They just do it in different ways. All right, moving forward. All right, so a trust is a set of documents and nothing more, just like a will. So a trust is a set of documents and nothing more. Before you create a trust, you must name the trust, right? So some individuals choose, crazy names like a Marvel superhero or something, right? You can do that. Right? I don't recommend it, but you can, right? Others intentionally choose names that are not associated with them to hide their assets, which is strategically fine and relatively effective, right? And I'm a commercial litigator, so that would be something I would be doing, trying to find someone's personal assets, to meet some sort of judgment or whatever, right? So it's not a bad idea. It's not the greatest idea on earth, but it does frustrate the litigator, and it does take more time to potentially find things, right? If maybe not. It just really depends, right? So if you're not interested in hiding your assets for whatever the reason may be, right? Or you're not interested in just coming up with some, Marvel superhero name, right? I do recommend just using probably your last name and adding, living trust into it. Like for me, for example, my last name is Papa, so my trust would be the Papa Living Trust. Okay, now that you understand that we have to name the trust, next you have to understand your legal positions when it comes to a trust, right? So you would be the grantor, the trustee, and the beneficiary of your trust after it's created, right? Or you and your spouse, right, would be the trustees, the grantors, and the beneficiaries. So what does that mean? So let's just start with grantor. Grantor means you've created the trust. Okay, you've created the trust. Next, trustee. A trustee is responsible for administration and distribution of the trust. So you and your spouse or you alone are solely responsible for distribution. And then beneficiary, who receives the proceeds of the trust, right? And you would also be the beneficiary of your trust, right? Now, of course, upon incapacity or death, these positions do start to change, right? Where the trustee position moves from maybe you to your spouse, or if it's just you, to you and the next trustee you've selected to now distribute your assets, right? In incapacity, distribute to you because you're sick and you need them to take care of you, or in death because you've died and now your assets need to go to those that you've selected as beneficiaries. Moving on. All right. Let me see here. So the trust will include a series of clauses used to assist with tax planning, special needs planning, possibly asset protection planning, distribution, etc. Right? There's many clauses, and this is where trust can get very tricky. The language is incredibly important, and because it's all that will matter at the point when the trustee passes away, or really long-term incapacity, right? It is critical that the language reads the way it has to read, so that execution of the trust goes the way you want it to go. And this is really where people can get themselves in trouble, depending on who they go to create that trust, or possibly not even understanding what they put in that trust, right? Because there are things you can do in a trust that you may not even be aware of, right? Especially for mixed families, for example. You can choose to asset protect your items. For example, in Texas, it's community property estate, meaning if you're husband and wife, unless you're a mixed family, so you have children from another marriage, right? You can essentially say, at my death, I want all my assets that are half of our marriage to go into a decedent's trust, right? And then, of course, those assets can be used to take care of my spouse, but my spouse can never dip into those. And that does a couple of things, right? Number one, it makes sure that your assets will eventually flow to your beneficiaries. Number two, it does provide for your loved one, your spouse, for health, education, maintenance, support. But also, if your spouse is ever sued or divorced, in that judgment, they can't get a hold of your assets, right? Because your spouse will simply say, I don't own them. Yes, they support me from time to time, but I don't own these assets. Those assets were owned by my late spouse, who's deceased, and now they exist in a trust with the trustee managing them, and meant for the beneficiaries. So really neat things also with the children, right? Rather than leaving all the assets to them just outright, like you see beneficiary designations, you can leave in trust, which is great. It's a great protective measure. I'm working on a case right now where a family received assets, that were unprotected, right? And now they're vulnerable, and now, they're paying the price for that. So let's see here. So moving on. Now, I mentioned it once, and I'll mention it again. It's very important, right? Unlike a will, a trust will work if you're incapacitated or you've died, right? It's huge. A will only works when you're dead. A trust will work if you're incapacitated or you're dead, meaning the trustee, upon your incapacity, can now distribute your assets to you to take care of you, right? While you're in the hospital. Maybe something happens psychologically or something, right? Where physically you're okay, but mentally you're not, and it's gonna be a long time, right? So the trustee's now equipped, set up to take care of you. Of course, a will has a financial power of attorney, medical power of attorney to do those things. However, right, as you may know, financial power of attorney is not that easy to use, right? So when you have the added benefit and strength of a trust, you have someone who can immediately get into those assets upon incapacity as a trustee and potentially durable power of attorney, right, to help you during that time of incapacity. Not to mention, a financial power of attorney terminates upon your death, right? So what do you do when it's terminated, right? Trust does not, right? It does not terminate. Now the trustee still has access to those assets to distribute them. So it's phenomenal how that works, okay? Let's see here. So after you've signed your trust, you've completed your trust, you're happy with your trust, next is the funding process, which means you're putting items into your trust, right? Your home, your business, your bank accounts, your brokerage accounts, they'll all go into the trust, right? And your life insurance, retirement accounts, you could choose to name them the trust of the beneficiary or choose not to, right? Because those types of accounts will actually avoid probate court. Now, you may know that there are other ways to take the other property I just listed, the home, the bank, right? And also avoid probate court. True, correct. It is possible, right? However, it can create considerable problems, right? And what are those? Well, this is how that goes essentially, right? So let's say that you have certain assets avoiding probate. Let's just say life insurance, right? It's commonly known to avoid probate court, goes straight to the beneficiary. Well, number one, did you name a child as the beneficiary? Okay, well, if you did, mistake, right? Because now the money's there, has to go to court, and you have to decide who's going to be in control of that money, and there's going to be potentially an argument about that, right? So maybe you didn't do that. Maybe you avoided that mistake, but then still you've named someone who will be in charge of the child to distribute the money to the child. Well, here's the thing: when the person that person you've designated to get that money, and told them, I want this for my child, you've asked them to do that. They don't have to do that, because here's the thing: that money is for them, right? It's going to be for them because you've given them the money, right? So it gets tricky. It gets very tricky at that point. With a trust, you don't have that problem. That's not an issue, right? You don't select a beneficiary to get your assets, and then that beneficiary has control of the assets, and then based on a handshake or the words exchange, they're going to honor the deal, right? Because what I've learned over time is that individuals generally, it's not necessarily greed, it's need. Need is going to drive them to potentially use your assets for something other than your child or whoever you want them to use the assets for, right? If you think about it, as we get older, our parents get older, grandpa, whatever, right? Things happen, and the need for money grows. It doesn't reduce, it grows. So for that reason, and I've seen it, right? Individuals, once they know that they have a possible claim to any assets, they potentially use those and don't distribute them as you want it. A trust eliminates that, because a trust says, look, you're not a beneficiary of this. You're just a trustee. And because you're a trustee, you can be replaced. The beneficiary can replace you if the language is in there correctly written. The beneficiary can replace you. You're just a trustee. Yes, maybe there's some compensation to you as a trustee to distribute the trust is case, but you're simply a trustee. If you were to use those assets for yourself or do anything, right, beyond your duties as a trustee, yeah, you could be sued, right? So huge benefit of a trust. All right, so let's go ahead and go on to a will. So what is a will? A will, like a trust, is a document. And it's a document that's managed by and controlled by the estate and probate code, right? Generally, after you write your will and write it is what you want, right? And I'd say the courts generally want wills to be in a more simple version, right? They don't necessarily like them to be too complex, right? A trust can be a lot more complex. Wills generally want them to be less complex, right? Distributions to be less complex, from what I've seen. So that's the first step, right? And then you decide who the beneficiaries are, and then you decide who's going to distribute those assets to the beneficiaries, named the executor, right? So the executor, unlike a trustee, an executor has no power over any of your assets when you're incapacitated, unless you maybe name them on the financial power of attorney, right? Or when you've died, until the court has approved them as executor, right? And that can take 6 months here in the courts here in Texas right now. The trustee, on the other hand, is going to be the trustee, right? Upon your death, trustee is locked in, no debate, trustee gets moving on administration, right, and distribution. Executor, not the same, right? Have to now file with the court, get to an attorney involved, and file into the court to now become the executor to now distribute your assets, right? The assets being your home, your bank accounts, brokerage accounts, vehicles, personal property, yada, 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 right? Now, life insurance or retirement accounts will go, they'll avoid probate court, they'll surpass probate court, but a lot of those accounts will not. And now the executor is in a position very different than the trustee, right? The executor is in a position where they're in control of some of your assets, some are just flowing to beneficiaries, right? And that does cause potentially some conflict, because individuals are like, why is this guy getting the life insurance? And they made a deal with life insurance that it would go to yada, 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 right? Well, the executor can't control that. They can do nothing about it, right? Well, the trust, everything flows to one individual who's now distributing everything just as the grantor decided it should, or the grantor decided it should flow. So it does lead to situations. In addition, in Texas, there has to be 2 probates upon, like, if you're married, upon the death of the first spouse, 1 probate, and upon the death of the second, a probate. Personally, I haven't seen a probate for less than $10,000 attorney fees, that is, to date. This is where attorneys make most of our money. We make it in probate court, not in estate planning, not in creating trusts or creating wills. We make it in probate court, because probate court is a government process, right, which can take time. And if there's conflict, it takes even more time, more attorneys get involved, and most attorneys in probate work on billable hours, right? So you're just getting charged. I saw recently in one of my probate forums, the attorney was like, well, I'm about $30,000 now. It's been 2 years I'm working on this case, right? They should have just done X, Y, Z, right? Is what he's saying. Why didn't they just do this, right? Well, 70% of America is not going to have a plan at all. So if you're listening to this, you're someone who actually wants to have some sort of plan, right? 30% will have a plan, right? Of those 30, I don't have a stat for exactly who has a poor plan, who has a good plan. I imagine like 15% probably have a good plan, while the other 15 don't really have a very good plan, right? Meaning that attorneys will get involved, it'll be more costly, and they really don't know it, right? The 50% probably have a very well thought out plan that's been pressure tested, it's worked very well for them. Anyway, so moving on to the will. So let me see here. Let me see, I just want to see if there's anything else I've been covered here. So yeah, after the executor finally gets power to distribute the assets, right, they have to go to the county for the home, the bank account for the bank accounts, and everything else, right, as an executor would, to now distribute all those assets to everyone that was listed on the will. Let's see here. Now, as I mentioned this before, and I'll mention again, right, the problem with the life insurance, retirement accounts, or any other accounts that you're doing beneficiary designations is that the person you're giving that those assets to is under an obligation to provide those assets to whoever you've decided they're supposed to go to, right? There's no obligation. And if there is, let me know. I'm not aware of any, right? So the question is, how do you force them to do that, right? Well, without a trust, it's really not possible, right, to do that from a legal standpoint, right? Because, I mean, you select one beneficiary, the beneficiary gets the assets, those assets go to that beneficiary, right? So, and like I said, the world seems to move, that I've seen, more on need, less on greed. So although you have a great relationship, or whoever it is, your family member, at the end of the day, they, we're talking like 30, 40 years from now, they may not do exactly what it is you want them to do, right? And at the end of the day, too, when you have assets flowing to all these beneficiaries, not like a single point that's distributing them all, right? You potentially are creating more conflict in your family because there's more uncertainty, right? Things are just flowing in honestly, like in an odd way, right? Because no one's able to capture it all, right? In a trustees capture it all. It's well managed, well distributed, and you move on. I remember a woman told me she was upset. She goes, "Oh, my mother left me a trust, and it's taken us a month to minister it, right?" And I was laughing because, I mean, I know probate can take 6 months or longer. So and it was very well done. And she was actually happy. And then when she learned that, oh, I didn't realize, that other individuals are dealing with this and having much larger issues. Okay, let's see here. Let's continue. So that completes my discussion on trust. Just wanted to check, make sure there's nothing else for me to say. Hope you have a great week, and thank you for listening to this video. Bye.